Hello, everyone. Welcome again. We were discussing about mediation and good office. So, mediation, as we have seen that being done by the party, them by the powerful nations, by neutral nations. It can be done by international organizations and by persons. So, basically, the third party is to encourage the parties to undertake certain conditionalities and thereby agreeing upon the solutions. Sometimes the mediator also offers proposals to help the parties to identify and reach to particular solutions. Saying that, this point, the intention of saying this point is that when we'll be discussing about conciliation, perhaps we'll try to make a demarcation how mediation is different from conciliation. Well, the definition of conciliation has been delivered in 1961 by Institut de Droit International. It's a French name, Institution of International Law, by the globally renowned scholars of international law. It says that a method for the settlement of international dispute by any nature, according to which a commission set up by parties, either on a permanent basis or on an ad hoc basis to deal with the dispute, proceeds to the impartial examination of disputes and attempts to define the terms of a settlement. So, this is actually gives different features of what should be there in the conciliation. Uh, Conciliation between states, third parties cannot take initiative on their own, and therefore they are appointed on the basis of an agreement by the concerned parties. Conciliators can be appointed on behalf of, on the basis of their function. Sometimes a head of the states can be a conciliator, Secretary General of the United Nations can be conciliator. Most conciliators were performed with commission composed of several members, but there can be single individual leading the conciliations. Now, this is where if you recall what we talked about mediation, is that in mediation or good office, the third party takes initiative, approaches the parties, gives them solutions, whereas in conciliation, the conciliation is at the liberty of the parties themselves. They will agree, and then only conciliator will proceed with his functions, and the functions are prescribed by the parties themselves. So, in terms of the mediators and conciliators involvement, mediator involved in a larger and meaningful way. His involvement is much more than the involvement of the conciliator. Single conciliation has been, an example during East African communities asset distribution, which was held in 1977 when there were three East African countries, Kenya, Tanzania, and Uganda. They asked Swiss experienced diplomats, the diplomat is from Switzerland, Dr. Victor Ambrecht, to make proposal for the distribution. So after 4 years of investigation by the concerned uh, expert conciliator, the total asset has been accumulated and decided accordingly. So the conciliator finally suggested that 42.7% asset will be with Kenya, 34.3% with Tanzania, and 23% for Uganda. So this is what an example of a single individual, taking the conciliation. It mostly used when the dispute is in a minor nature. There has been less than 20 cases, as has been pointed out, that in last 70 years of modern history of international law, only some of the notable cases of conciliations. So, conciliation, the conciliator's rule is a prime criteria to demarcate it from the mediator or good officer. You know the name of the former Secretary General of UN, Kofi Annan, the late Kofi Annan. He was a mastermind in being a mediator or conciliator, sort of, the international personality. So, as it is said that mediator or conciliator can be an individual who has international reputation. So here is a question to you to prepare yourself for the next class maybe. Um, and afterwards we'll be asking in one of the discussions that if you are asked that to give the name of three individual persons who can be qualified as international conciliators or mediators. I'm sure I'll get the name from you. So be prepared about three names at least. Maybe those names in your list that will help you. So moving ahead, but before that, I suggest if you can read Article 284 of UNCLOS, which talks about a conciliation process. Article 284, please read Article 284 because it states that parties in terms of interpreting this convention may submit a dispute to conciliation in accordance with the procedure under Annex 5, and if it is accepted, then conciliation procedure will be applied. If they not accepted or not agreed, the conciliation proceedings shall be terminated. So by the invitation of either parties, with the application of either parties, conciliation option has been there in UNCLOS. The next one is arbitration. It is one of the fundamental modes of dispute settlements. And we have an experience, first-hand experience of ours being involved with arbitration. Bangladesh is involved in the arbitration of permanent court in delimiting its boundary with India. So arbitration is actually more formal than negotiation, mediation, or conciliation, more juridical, but exactly less than the court type, and sometimes it stands equal to the court type. So it's more on judicial nature. Conciliation and mediation usually and mostly in the political and economic nature, but there are legal disputes settled through negotiations, no doubt about that. But arbitration, it involves legal regulations. The most concrete achievement of 1899 Hague Peace Conference was the establishment of Permanent Court of Arbitration, and that was a body since then functioning as a court of arbitration. It's more formal than the above measures. It's necessarily involves settlement of disputes in accordance with existing legal standards. Parties agree to submit the dispute to arbitration and thereby commit in respect in good faith to the outcome, and the outcome of arbitration is binding. The Permanent Court of Arbitration has competence in all arbitration cases submitted to it by agreement of the parties involved. Because if anybody is willing to go for arbitration settlement by the Permanent Court of Arbitration, there are a list of arbitrators appointed by state parties, and from there parties choose the arbitrators. So the options are open, I think, for the states and who wants arbitration. Other than PCA, there are other ways parties can settle their arbitrations. They can formulate their own rules of procedures for developing the arbitrations. And if you look at the Arbitration Act of 2001, the Bangladesh Act, it also prescribes for domestic as well as international arbitrations. So with all this, I suggest you look more into the arbitration issue. That's a very emerging globally, nationally, particularly from the global context. If you look at international commercial matters, most importantly, investment matters, there are bilateral investment treaties and there are multilateral investment treaties. So these treaties provides arbitration clause and there are arbitration mechanisms for investments. Globally, this is the most demanding and attractive packages and mechanisms for the settlement of disputes, particularly in the area of investment law. A tremendous numbers of arbitration these being conducted. Thank you.